And, you know, this, I think, is a good recommendation. The only concern I have around it is if the child's school is not in session, that may be a bit of a problem, but I think we can write the policy in such a way that it was, it recognized that as a possible exception.
In addition to that, school social workers contacted legislators last year about the fact that when they reported something, nothing ever came back to them, and they didn't know what had happened with the child's case, and they were concerned about closing that book formally.
What was it, had a bill, didn't it?
We actually have instituted a new part of our reporting system that allows mandated reporters to register within the system, and it allows them to go ahead and put all the boilerplate information concerning their name, address, telephone number, or the contact information, and their affiliation with the school, and what their mandated reporter link is. When they submit the report via that link, it automatically acknowledges it. Part of the concern that the school social workers have is knowing about the welfare of the child. The other part is also about the liability that's incurred in the event that they don't have proof that they've made a report. So that system, I understand, has been very well received by the school social workers. But it really should be something that is just a common expectation of any reporter. They need to have the report acknowledged as long as they identify themselves and give contact information. So we will continue to work on that.
If you take that one step further, how many reporters actually want to know what the outcome is? I mean, do they, because I'm sure some of them who are reporting feel invested in the safety of the child.
Right.
So what are you allowed to tell them?
At this point, to be honest with you, I don't know the answer to that. I need to check on what the requirements are. I can tell you that I hear a lot of concerns around not knowing what happened in the case, but you have to view that also through the confidentiality rights of the child and family. So we'll take a look at that, and I'll report back to you on it.
One other point that I would make in the school system is that when children are taken into care, there may be a bit of a disconnect. The school may not know for weeks that a child has changed placements or is, you know, living in the same district but with a different family. And so being able to communicate with the school.
Tie back to Chairman Willard's recommendations,
Yeah.
correct, about what you can share in terms of information and doing that more
Right.
expediently to help the school understand what's going on.
Right, because often the alleged maltreater is the person who is on the student's records, and so if they're changed placement, you know, to be placed in a foster home, their alleged maltreater is the only person that's indicated as parent. So it's helpful to expedite.
One of the things that I can do is share an education protocol that we've written for our county, because one of the things that McKinney-Vento Act provides that every county will have a homeless liaison. And the department needs to know their county's person and the county where the child might be enrolled in school, because when those two communicate, those children can be enrolled immediately. They don't even have to have records, because this also happens in the domestic violence arena, where there's, because of the domestic violence issues, they're to be allowed to enroll in a school without records. So we have protocols and safety things in place, but the issue becomes education and training.
So are we also notified, because I know that parents will pull a child out when there is suspicion of abuse, is DFACS notified if a child is being pulled? Is that something worth considering?
The school system doesn't know that there's a defect case in that
Right.
situation, so we wouldn't know to communicate with
Because I
them.
know that we've had several instances where because we
Mhm.
know a child is being pulled from school or put something, it's difficult to track the family. So how do we, what is the answer there?
I think there's a lot of uncertainty on everybody's part as to whether we can actually share the information that a investigation is ongoing. And so some clarity around that is probably in order. I think that it is important for the school to know those kind of things. Again, you're balancing the need for the school to know with the right of confidentiality on the part of the child and family. So I think that this is something I've encountered several times in my career, and there is there's usually very little clarity around it. So you have to talk to attorneys before you actually share that. I'm asking for clarification as we.
So Chairman Willard, is that something that we could maybe have some clarification on as to?
We'll look at
Yeah,
that, sure will.
Okay.
That's what we'll-
Because that is a gap
Part of
where
the
we
whole
have
study,
kids
yeah.
falling.
Well, one of the
out
interesting
cracks.
things is the courts are open now. So, you know, if the case is in court, we can communicate openly and have the school present and participating. But if it's not been petitioned into court, that's a different issue.
One kind of related recommendation you have here is from the first one you talked about in regards to homeschooling families. I would just caution us to be very, very narrowly tailored in how we deal with that. I understand that there are a few cases where parents are doing that, you know, because they're trying to avoid defects, but the vast majority of parents that are homeschooling obviously are really committed parents that are homeschooling. So I would just encourage us to be very, very, very narrow in how we apply that recommendation.
I just want the legislators in the room to know it was not my recommendation.
My thought on that, Aaron, is that in eligibility, there could not be a pending investigation. They would have to have some kind of clearance letter or something that would indicate that to be eligible, there was not an ongoing or existing case regarding abuse and neglect.
Yeah, I mean, when you start talking about imposing limits on when a parent can begin homeschooling, obviously, you know, parents sometimes pull their children out of school because they're being bullied to, you know, a horrible degree. You can't tell a parent they have to wait till the semester is over before they can do that. Those kinds of things. I just want us to be very, very narrow in how we interpret those things.
You're waving a red flag in front of the bull is what you're
Well,
doing.
We understand that.
Talking about having the court be the ones that have some discretion about that, if and when there becomes a obvious case where someone's doing it as a way of avoiding defects, investigation, or otherwise.
Right, and that's the point, I have no concern about that. I think that's making it very
But I agree
narrowly
with you.
tailored.
We have to be very careful. Red flag, and you waive that homeschooling limitations in the legislature.
But you can potentially avoid that if you can shore up the other pieces, which is the schools and defects of communicating about there's an investigation, I'm pulling the kid out. You
That's right.
can
That's why
avoid that.
it's very related to that overall point
Right.
about notification and when a child's
Yeah.
educational setting is being changed while they're in the middle of a defects investigation. I mean, I
Right.
think if you can
Address that.
address it in that overall piece, that's probably the more tactical way and way to narrowly tailor that piece.
And even outside the conversation regarding homeschooling, I think this is really pertinent to the larger question about when you involve courts. We currently have wide latitude in when we ask for a protective order from court. In my estimation, we currently don't use that to its best effect. We wait until it is an emergency situation before we involve the court in most cases. And so we're going to be looking at policy with regard to making that more of a early on option as opposed to waiting until it's an emergency
Probably
situation.
that's an education process. And something would fall back to the rewrite of the juvenile code and putting the chin provision in there is to give the courts better input about what needs to be done for the needs of that child, not just in a criminal situation or quasi-criminal. So that's gonna be an education process for the judges too, more so than anybody else.
We've been building a practice model of doing family preservation and not doing removal, but exercising court jurisdiction, and it is very effective, and I'm very excited about that.
Yeah, I'd just like to say from the committee's perspective, we had a lot of discussion about it, and we put in the rationale some thoughts and things that we've heard and all that. What we really wanted to do is kind of bring it up to have some discussion about, because it is a loophole that needs to be closed. But we want to invite the homeschool people who homeschool and those that are that do that work and those advocates to the table to help us to solve how do we close that gap. We don't want to infringe on anybody's rights or anything, and I think if we can incorporate closing that gap with the communication between DFACS and the Department of Education and involving the local school, I think that would kind of satisfy that closing of the gap that we envisioned. But we didn't intend for
But we did feel like it was strong, we felt strongly enough in the committee that. And I had this conversation with Melissa already, so just, I did have this communication with your chair, but she's not here, so I thought I would bring it up in this setting as well.
Lamar?
Another thing
I
that's
already,
good-
I said
Sorry.
that to me.
And I was told, and you said, I've been here, I know.
Lamar?
Judge Walker, we have homeschooled for 28 years. And I'm sure that good committed homeschoolers, they understand what we're trying to do and explain to them why the purpose of us discussing this. They'd be very supportive because they're concerned about those children too. And as I told y'all in the meetings, I have reported some folks who were homeschooling in the past, mainly not because of abuse, but because of getting no education. And, I think good committed homeschoolers, you know, belong to good, strong homeschool associations. We got lots of activity. You know, we would be very interested in seeing things, something, I don't know the answer, but something that would cover our concern of children being hid or, you know, abused without some type of public knowledge.
I was gonna suggest we do this, go through the homeschool associations.
Right.
You don't wanna have
Yes.
individual parents and all that kind of stuff, but you're just gonna have them that way. I mean, just, it's not, you wanna go, if you're gonna do something like this, go through the associations and get them to buy in, and then they can explain it to their members who they trust, because they don't, a lot of these people are not gonna trust what the government has to say. Sorry, that's just the
It's
way.
the reason they're homeschooling. I mean,
Yeah,
it's the reason many of them.
that's exactly right.
So they're
Trust me.
already gonna be very,
We-
very skeptical of an organization like DFACS intervening in their family,
That's
which they
exactly
hold to be
right.
private
So,
and sacred.
You go through,
So-
whenever we do this, go through the associations, what you do.
And I think the spirit of the initial conversation was recent fatalities, and that children were, you know, under the guise of homeschool, but not actually being homeschooled, and so it's very few cases, but that was kind of the spirit of the conversation that was brought up.
Well, it's really the notification that's the key. Had we known that those children would be pulled from the school,
While
and
there's
that's
an investigation.
you know, while there's an investigation, that would have been prevented.
Well, the other thing is, the notification goes to, the state and not to the locals anymore, so there's no way for, the local folk to know what's happening with the kids.
I think you can change, I mean, I think that's changeable, a lot of work, but maybe that needs to be changed so it goes to the local. I'm just thinking about one county who's tried to do that.
And I think most of the families we're talking about have not joined the homeschool association.
Absolutely.
So that's where I think the homeschool association would be very supportive, because those are the ones, as was already shared, that they're concerned about. They have just, and I've seen that happen in other cases, not just abuse, but they just literally have left children home, in homes by themselves, and they have been, you know, victimized in other ways as well. So it's sometimes just not to deal with the consequences of being questioned about any of their behavior. So it sounds like it's not gonna be frequent, but it's definitely worth saving a life or saving future abuse, when someone is running away from being investigated.
Representative Willard?
I have a question, something else.
You recognize me?
So, if you bought the car around here,
Senator.
if you bought the car around here,